Okay, I am going to revisit and reconsider the statement of case that was presented in the leave to file an information in the nature of quo warranto that was dated for August 3rd, 2017, and was submitted to the Supreme Court of Texas on that day, but was in another manner provided as context to members of the legislature the day before, which would have been 4 years ago today, wherein I sent them what was identified as a Declaration of the Rights of Texans. And the intention was the intention in submitting that was to let them know that this was an immediate threat that I understood had just happened and that it required an immediate response. And I submitted it to the legislatures first before I then took it to the Supreme Court. And in the Supreme Court, I named as, in the motion to the Supreme Court, I named as respondents alleged Governor Greg Abbott, alleged Attorney General Ken Paxton, and members of the Texas State Legislature as a class. Now, per U.S. versus McDade, which was referenced in the petition for a writ of habeas corpus that had already been submitted to the Texas Court of Criminal Appeals, there was actually justification for doing exactly what I did in naming them as respondents, including as a class. And this is something that will be presented upon further explication moving forward. But I want to revisit matters related to what was stated in the case. I had said that the concern was that they were involved in sabotage that constituted a course of action with the aim of sedition against the people of the state of Texas. I now understand and have information regarding precedents set not only within the Supreme Court of Texas, but also on the level of the federal government, identifying and justifying how the actions that they engaged were in fact sedition against the government of the people. The people of the state of Texas actually quantify and qualify the authority that is then delegated to members of the legislature and the executive, as well as judicial branches, by the way. And that what they did through the legislature, and then what the governor allowed to do through the legislature, and what the attorney general refused to prevent against, including through an appropriate judicial review or through a invocation of processes that could have provided legislative relief, constitute acts of sedition insofar as they were intentionally engaging in what legally qualifies as sedition to undermine the government of and by the people. Not only that, it does say that they were engaged in manipulation of multiple Texas codes of law. And this one I specifically say, including the misapplication of the Texas Code of Military Justice and the Texas Tax Code. I've already mentioned a reference today, specifically information regarding the Texas Code of Military Justice or the Texas Military Code. And the matters related to the Texas Tax Code have changed since then. The September 1st of 2019 date was very important. And specifically, part of what was important about it was changes to the law, or alleged changes to the law that actually are unconstitutional, regarding confidentiality of information that is actually mandated for reporting in order to be able to apprise the people not only of the application of the Public Information Act or laws regarding public information specifically within the state of Texas, but also in consideration of other matters that would be related to people's engagement, including as a business person, but also as a person, an owner of property, and the manner in which their property would be available for consideration in taxation, not just within the state of Texas, but insofar as the state of Texas has not taken steps to formally secede from or to alter the government so that we are not beholden to the federal constitution. It's also in violation of federal tax law. As a matter of fact, there are several reports that I submitted around this time and then also attempted to follow up on, specifically to the state auditor's office of the state of Texas, that spoke to that directly. And just over this weekend, I found what was the second demonstration of an intentional and willful manipulation through the Texas Insurance Commission in co-conspiracy with the state auditor's office of the state of Texas in refusing to respond to the actual charges associated with what I understand are still open report numbers, while they instead use those in some sort of illegal scheme to provide securities in the form of reports or alleged recommendations that do not actually respond to the charges as charges. but rather, I understand, attempt to cover up for the crimes they were attempting to report. And so that has a direct implication on what were the specific allegations regarding abuses of the Texas tax code, including the Municipal Use Sales Tax Act that I contend was misabused in conjunction with unconstitutional changes regarding tax waivers. Now, at the time, the tax waiver of concern was an alleged constitutional amendment that came after the legislature had already passed and applied a tax regarding a waiver on the homestead of the spouse of a first responder killed in action, which was absolutely heinous. And I contend was actually aimed at an effort to attempt to extort or compel cooperation by members of law enforcement in crimes being promulgated within the state of Texas, including under the alleged auspices of being able to be covered by immunities that were the privilege of those that were serving in official government roles. But there have since been numerous other changes or alleged constitutional amendments, including changes to the tax code, including ones through 2018 involving presumably providing some sort of assistance to partially disabled veterans when it comes to charitable housing, and more recently, when it comes to, among other things, service animals. And the implications of these taxes are not only profoundly harrowing, but should never have even been put before the voters because they should never have been allowed to be acknowledged as legitimate by the legislature. And by putting them onto the people of Texas and allowing for them to masquerade as if they have constitutional validity, when in fact they don't, puts on the entirety of the people of Texas the failures of the government to act in a constitutional form and would libel the actual good faith and credit of the people of Texas were it to be allowed to stand, which is part of what's happening. And nobody is allowed to represent themselves as having a government office so that they can intentionally and willfully engage in unconstitutional acts with an intent to undermine the government, including the fiscal solvency of the government, so that then they can engage in processes of applying illegal liens on the people in violation of their 14th Amendment. And unfortunately, because the conspiracy is that comprehensive, the 13th Amendment as well. And so these charges still hold, and actually, unfortunately, only more information and more evidence has been provided since the refusal and failure to act in an appropriate time frame regarding the charges that were put forth in this manner. It also says that there were numerous acts that were outlined, including in the petition for writ of habeas corpus, that identify a specific pattern of racketeering. I contend that still holds. And not only does that still hold, but as I mentioned earlier, when they allowed for the e-storage and the misrepresentation of it as a habeas corpus in conjunction with other illegal actions that they engaged, that what they actually did was take what had been presented as part of the habeas corpus in a bill of exception, and they did something incredibly and intentionally and willfully illegal with it that is now part of what appears to be a very long-term scheme aimed at accomplishing those ends that implicates the national security apparatus of the United States and also materially jeopardizes the safety and welfare of the people, including in manners connected to a willful refusal to appropriately disclose information that was necessary for us to be able to be safe and to be secure in our persons during this time frame. Now, one of the things that's going to have to happen moving forward is there's going to have to be a consideration of actions that were taken up to and including on the level of the Supreme Court of the United States in 2009, or actually 2008 through 2010, that provide a form of material cover for these kinds of things to be allowed to be promulgated. And this is a very serious matter because when I presented this, originally I presented it to the state of Texas because at the time the consideration was the direct impact it had on the people of the state of Texas. And per actual application of Texas constitutional procedure, in so far as the specific matters at hand were happening within the state of Texas, the Texas Constitution provides a unique means through which remedy could have been obtained insofar as this may have been something that was unduly influenced or was part and parcel with actions that had been intentionally and unconstitutionally engaged on the federal level, i.e., if the inception of the criminal conspiracy was on the level of the federal government and it was being put onto the state of Texas, and the state of Texas was being coerced or compelled into cooperation with crimes promulgated on or by the federal level. The Texas Constitution has unique remedies for addressing that in a way that could have actually not only supported the people of Texas, but also our allies in other states that were dealing with something comparably. If, on the other hand, the state of Texas itself was an intellectual author or was the originator of either the specific conspiracy or elements of the conspiracy, or was in co conspiracy on a state level in conjunction with matters on a federal level to promulgate this conspiracy, then the Texas Constitution would reveal such. And it has. And the fact that two presidents had previously been identified as coming with and from the state of Texas, and then another president was identified as coming from an area of the United States that involves primary jurisdiction over a primary water system that provides for the state of Texas. These are very materially relevant factors when determining who is ultimately responsible or accountable for the policies that have been allowed to promulgate and the refusal to hold people accountable for intentionally and willfully engaged violations of the Constitution. So, insofar as I made the statement of case that I did at the time, it still holds. And not only does it still hold, unfortunately, there has not been any successful action to repudiate or quash the charges. Nothing has quashed the charges. On the contrary, what has happened is an effort has been engaged to try to intimidate, and an effort has been engaged to try to exacerbate what was the material conditions at the time in order to try to eliminate any information that there was already foreknowledge of a massive criminal conspiracy. It has not been successful.